As we come across California state statutes found in the codes, obviously, one of the 29 codes or more of them, we find statutes that utilize court decisions. And there are a number of instances where California statutes refer to court decisions. They may abrogate them, or they may even confirm appellate court decisions that have been rendered in the state or federal courts concerning California law. Now, in most instances, these statutory references to reported appellate court decisions occur or accompany legislative intent language, where the legislature makes certain findings and declarations. But there are plenty of other instances in which the legislature uses the court decision in an affirmative statement. So I've got a couple of examples to share where statutes reference a court decision as part of legislative intent language first. A simple one is nothing in this chapter is intended to limit the public's right of access as provided for in Long Beach Police Officers Association versus City of Long Beach, a 2014 California Supreme Court decision. Another example I pulled is the legislature finds and declares that public access to information concerning civilian complaints regarding peace officers, including the records of proceedings of civilian law enforcement review agencies, is crucial to safe and effective law enforcement in this state. It is the intent of the legislature in enacting this act to abrogate the decision in Copley Press Inc. versus Superior Court, which was a 2006 California Supreme Court decision, in order to restore public access to peace officer records and to restore public access to meetings and hearings that were open to the public prior to the Copley Press decision. Now, I came across a few examples where there is reference to a court decision that is in a statute. So the other two were uncodified language. So they're not in the statute, but they were part of a bill, generally in plus sections. And so the next two examples are where the court decision was specifically placed into statute. And so one is this section does not supersede or affect the criminal discovery process outlined in Chapter 10 or the admissibility of personnel records pursuant to Subdivision A, which codifies the court decision in Pitchess versus Superior Court, which was a 1974 California Supreme Court decision. Another example is utilizing that Copley Press case, where they said, notwithstanding Subdivision A, Subdivision F of Section 6254 of the Government Code or any other law, or the holding in Copley Press Inc. versus Superior Court, records and information obtained from records maintained by an agency or body established by a city and county, local government entity, state agency, or state department for the purpose of civilian oversight of peace officers shall not be confidential and shall be made available for public inspection pursuant to the California Public Records Act under the Government Code. So in most instances, the California legislature reacts to an appellate court decision, either because they want to change the law to reflect their support for the court decision and basically to codify it or put the decision into statute, or to abrogate it, meaning to overturn it, and in which case they're going to overturn the court decision by a statutory change. Also, in other circumstances, the legislature may utilize a court decision as part of some legislative intent statements. And while those statements don't carry the force and effect of law, the courts themselves can also accept or reject these statements of legislative intent, but clearly they delineate the legislature's view on the particular matter.